All right, as expired, we are now on the clock. Good morning, members of the Board of Appeals. We are here for a public deliberation in case number 21-098A, 11307 Beach Road. This was a petition and appeal, de novo appeal from a petition for variance relief from sections 400.1 and 400.27-B-1-2. As you gentlemen might recall, the issue is a fence height. Through the testimony, we learned that there's allegations. There was some confusion by the petitioner as to what constituted the front and the back of his yard. That confusion carried over into county officials who erroneously basically gave him a permit for a 6-foot fence in what would be deemed as the front yard. That fence has been built, so it's on the ground now. Also, there was an existing structure that was supposed to be maybe in the front or the back. If it's ascertained that that's in the rear, then that petition becomes moot and we're just dealing with the fence. If the waterfront is the front, I think we determined collectively during the hearing, with all parties agreeing, that variance relief is still required if one is trying to put a 6-foot fence in what would be deemed the front of the waterfront. There was a prior decision by I think it was the Board of Appeals, on a neighboring property where the issue as to what constituted front and back was litigated and determined. First of all, just before we start anything else, my colleagues, do we agree or disagree that the waterfront is in fact the front of the property? Do we have consensus?
I agree that it is the front of the property in this
I
case.
agree also.
All right, so moving to step 2, by doing so, I believe we eliminate the variance through 427B1-2 with the structure. I think we're just dealing with the variance for the fence itself. I believe the requirement is gentlemen, is it 42 inches?
Yes, I believe.
42.
42, and we're all in agreement that 6 feet is more than 42. So doing so, we have agreed that there is in fact need for a variance. A little bit of history too. We heard a little bit about the protestant, Mr. Welsh, and what was going on his property in the past and different fences. We heard his testimony as that he believed that that fence was too high due to the topography of his lot and also due to his view of the water itself that may be impeded by the fence height. The petitioner testified as to the unique slopes of his backyard, the need for the fence height due to things going on in Mr. Welsh's yard. Also, the elephant in the room is in fact that the county actually had issued a permit which caused this fence to be built in the first place. There's some contention. Basically, I'm sure the petitioner is going to say he was quite forthright with the county. They gave him bad advice. I'm sure the protestants would say that's partially the petitioner's fault because he didn't know front from back. There is case law. This board has sort of dealt with it in the past. The Lippitt's case basically states that, permits, and Marzullo v. Call, permits can be revoked. Illegal permits can be revoked. And that's just part of the deal. But there's also something called municipal estoppel. Municipal estoppel is when basically you've relied to your detriment on the decision of a government agency. The case that deals with that, most importantly, that actually went in the way of the petitioner is a case called Permanent Fin Corp. v. Montgomery County. It was a 1986 case where a large building in Montgomery County was actually built several floors higher than it was allowed to be done. The court in that test saying that if the agent of the municipality was acting in good faith and did not do an illegal act, that sometimes that type of municipal estoppel can be factored in. So just to be clear, municipal estoppel is not part of the variance analysis that we do. It's a factor, I think, over on the side. So if the variance request goes one way, you don't look at municipal estoppel. But I just threw it out there because it's a thing. It's rarely used, but it has been used as recently as 1986 in the permanent fin matter. So doing what we do, getting to any variance of such, we're going to start with factor one of Cromwell and whether we find uniqueness in some fashion that would allow us to have a further discussion. Mr. Pennington, how are you feeling on uniqueness, sir?
As far as uniqueness, I actually think that Mr. Gargiulo satisfies that first prong. When you look at just looking at the my neighborhood view that was presented, and when you look at you can see the topography of the lots. When you look at the actual topography of just the shape of the lots, those lots on that waterfront, even though when you look, some of them look like they're perfect rectangles. When you look at the actual the view, there's a lot of differences between the shape of a lot of these lots. Some of them protrude further out into the water. Some of them are set back. But the most important thing, I believe, is the way the elevations are. So apparently the testimony was that the yards are tiered. Some of them, it doesn't look like the one on the west side of Mr. Gargiulo's is tiered, but Mr. Gargiulo's and Mr. Welch's properties look like they have different levels that go down towards the water. And then and I think fairly important in this case also is Mr. Welch testified that Mr. Lee's property sits higher than Mr. Welch's property. As you're going east to west, Mr. Lee's property sits higher than Mr. Welch's property. And Mr. Welch's property sits higher than Mr. Gargiulo's property. I think that satisfies the uniqueness prong. I do.
Mr. Lauer, what do you think, sir?
I would tend to agree with Mr. Pennington. I believe when I asked him about the fence and the view, Mr. Welch said that the view wasn't obstructed on one side, but it was obstructed on the other side of his property by Mr. Gargiulo's fence. And that would lead me to believe that we have a slope that comes across here, similar to what Mr. Pennington, I think, was saying. And looking at the map, it does look like there is uniqueness in terms of the shape. I mean, as we all know, general law principles say that every piece of land is unique, but I think in this case, there was testimony that I would tend to support that contention.
I thought it was interesting too. You know, there was a prior case with Mr. Welch's property some years ago. There was some notation at some point in time that there was actually a request for an 8 to 10 foot fence. I can't confirm if that was true, but I do know that some relief was granted allowing a 6-foot fence at some point in time. Based on that, there shows that there was the unique factors described by Mr. Welch are sort of shared by the petitioner. It kind of is a double-edged sword. He says he has these slopes and he would like the fence to be one way for his view. And the petitioner has these severe slopes and would like to have his fence to protect his privacy due to the same topography. So it's kind of all depends what side you're arguing. But based on that, the uniqueness of the property in this case is directly tied to the relief requested, meaning that the uniqueness is brought on by the topography itself that sort of requires same. So based on those factors, I concur for those reasons as well. There is some precedent as to describing pretty much the same type of property that some relief has been given So now we have that factor. So, all right, we will check the box as to factor one. Factor two, um, something that doesn't have as much as clarification under law, dealing with the hardship situation as to two and how we feel about that. So, Mr. Pennington, do you want to start with that one, sir?
Sure, Mr. Bell. Uh, so practical difficulty, undue hardship. The testimony that I've heard, Mr. Gargiulo speaks about, obviously because of the way that the topography is, he basically is looking right into the neighbor's yard. So we have, even with the 42-inch fence, so we have, it's a privacy argument. It, Mr. Gargiulo wants to build, I believe he said he wants to build a pool, a deck, or a hot tub and a deck. And the other issue is what the what's located on Mr. Welsh's property. There was testimony about he has a deck and a pool down near the bottom of the hill. And also there's a compost pile, which I believe from the testimony at some point the county was involved in, a compost pile and also yard waste that's piled up right, basically right on the fence line there. That's, I think that's that's the factors that I was able to glean from the testimony. I don't know if you guys have any more.
Mr. Lauer?
Those were the things that I seem to have here. Looking back through my notes again as we're talking here, that there was some things on the side there that he wanted to block and make sure he didn't see. He wanted a hot tub, put a hot tub in. That was pretty clear. There is this privacy issue, as Mr. Pennington mentioned. That's kind of all I have on that.
And
Well,
it's, and I would say just obviously every neighbor would have, I guess, a privacy issue. I guess what the issue is here because of the nature of that property. I don't, based on Mr. Gargiulo's testimony, it seems like 42-inch fence wouldn't provide the same privacy as, say, between my neighbor and myself, because our yards are situated, whereas, you know, a 42-inch fence would provide some privacy, and I think what the county code provides. But based on the way that the property is, I guess, and the 42-inch fence, just according to Mr. Gargiulo, doesn't cut it.
I thought in one of the county comments that were provided in the file previously, even though the front of this property is deemed to be the waterfront, on the waterfront, the activities of leisure and recreation take place on the waterfront, whether you want to call it the back or the front. So you have kind of this incongruous type of situation. You know, front yards, we try not to have really big fences in front yards, but it's kind of, you know, it's kind of flipped on its head when dealing with a waterfront situation. I'd like to be careful in my own analysis. The hot tub use or desire, I'm always very hesitant to put that in a practical difficulty situation, saying, you know, I'm having a hardship and because I can't have my hot tub. That is not part of my analysis. My analysis is, in fact, more of like Mr. Pennington said, the inherent desire for privacy in one's property, especially in that situation, which would otherwise, not for what it's called, but what it's used for. Though it's the front, it's used like someone else's backyard. Having privacy from things that are right up on the property and the neighbor's recreational use of their front yard, which is sort of a backyard, I believe does create the practical difficulty that would be required for us to check that box as well. So this is, for me, this is a strange set of facts in variance world. And it requires a careful analysis. Just because someone wants something for a particular use in their yard doesn't mean it's practical difficulty that they don't get it. But we have a situation here that is extremely unique due to what we call the front, what we call the back, the uses that are prescribed by practice as to those locations. Um, and again, going back to the different interesting kind of tiered shelving of topography of this property. So I'm in keeping then with the two of you as to factor two of a Cromwell analysis. That being said, um, previously, I don't believe we have to consider the other variance due to our finding at the beginning of our deliberation. So I make sure I have it straight. In fact, we are allowing the fence variance to remain. Before we started the Cromwell analysis, I did bring up the issue of municipal estoppel. Due to the fact that we are granting the variance, I believe there's no need to address any type of analysis as to whether or not that applies in this matter, or even if such would be in the purview of the board. I don't know if that's perhaps a circuit court issue, um, in an equity type of finding. But based on Cromwell, are we in keeping that we do grant the requested relief as to the fence?
Yes, I'm supportive of that.
I am as well.
All right, and gentlemen, do you have any further questions or comments before we close our deliberation?
I have
No, sir.
nothing further.
There will be a written opinion done in keeping with our findings here today. Once that opinion is issued, the process for appealing such is present on that opinion, which allows for judicial review to the circuit court if filed in a timely fashion. So based on that, thank you, gentlemen. Have a lovely day, and I will see you next time.
Thank you.